We're diving into a legal saga that all kicked off because of one single line item on a closing document. Yep, a surprise $660 fee. It's a question that probably hits close to home for a lot of us. You get that bill from your HOA, you look at a fee, and you just can't help but wonder, wait a minute, can they actually do this? Is this even legal? Well, for a new condo owner named Brian Sopatyk, that wasn't just some passing thought. That one question launched him into a years-long legal battle against his condo association, and it all revolved around one single charge on his bill. So how in the world did a simple fee snowball into a full-blown administrative hearing? All right, let's get into it. And believe me, this was not a quick fight. This thing dragged on for more than 2 years. It all started back in March of 2015 when Mr. Sopatyk first got the paperwork. By August of the next year, he'd had enough and filed a formal petition. That led to a hearing, and then, get this, a rehearing way out in June 2017. So yeah, this was definitely not a simple issue. And here we go. This is the heart of the matter. At closing, there were 2 fees. One was a tiny $30 statement fee. No big deal. But then there was this monster, a $660 transfer fee. Now, here's the kicker. Arizona law has a really clear cap, $400 max, for these kinds of disclosure documents. So that $660 fee, that looks like it's way, way over the line, right? So from Mr. Sopatyk's point of view, this was an open and shut case. He saw a fee that was $260 higher than the legal limit, and he believed the condo association had just flat out broken the law. He wanted them to answer for it. This whole case is really a showdown between 2 different sets of documents, the official state law on one side and the association's own internal rules on the other. So first, let's look at the law. Arizona Revised Statute Section 33-1260 is super specific. It says, sure, an association can charge a fee for getting all the resale paperwork ready, but the total, the aggregate of those fees can't be more than $400. That was the legal line in the sand Mr. Sopatyk was pointing to. But the association fired back by pointing to its own playbook, the CC&Rs, that's their covenants, conditions, and restrictions. Their rules had a section that required every single new owner to pay something called a working capital fee, which was equal to 2 months of their assessment. And that money wasn't for paperclips and copies. It went directly into the community's reserve fund for big future projects. And that right there sets up the central question of this entire case. Was that $660 fee for preparing disclosure documents, which would make it illegal, or was it a working capital fee, which was totally allowed under their own rules? The whole verdict was going to hang on that one little distinction. Now, you'd think the association would argue about the law itself, but nope. Their defense was something else entirely. They basically said, we didn't break the law. We just used the wrong word on a form. It was all just a case of mislabeling. The association manager, a woman named Amy Telnez, actually testified under oath that it was all a simple but pretty critical mistake. She said that when she came on board, she was told incorrectly to call the working capital fee a transfer fee. So they were collecting the right fee for the right reasons, they were just calling it the wrong name. So their whole defense was that they never violated the statute in the first place. That transfer fee that looked so illegal, they argued it wasn't a transfer fee at all. It was their perfectly legal working capital fee, and the label was just a clerical error. And they didn't just say this, they brought receipts. They had board meeting minutes from May of 2016, right after Mr. Sopatyk complained, showing the board taking action. They looked at a legal opinion, realized their mistake, and immediately told their manager to fix it, to reaccount for the money and make sure every penny went into the reserve account, exactly where it was supposed to go. Okay, so you've got 2 completely different stories here. How does a judge even begin to decide who's telling the truth? Well, it all comes down to a legal idea called the burden of proof. So after all the testimony, all the hearings, the judge finally made a decision. Mr. Sopatyk's petition was dismissed. The association won. Now, let's unpack why. In a civil case like this one, you don't have to prove something beyond a reasonable doubt. The standard is much lower. It's called preponderance of the evidence. Basically, it just means you have to present enough evidence to make a judge think, yeah, it's more likely than not that this side is right. It's like tipping a scale, even if it's just by a little bit. And this is absolutely crucial. The burden, the job of tipping that scale, was on Mr. Sopatyk. It wasn't the association's job to prove their innocence. It was Mr. Sopatyk's job to prove they were guilty. And in the end, the judge's conclusion was crystal clear. The association told a believable story about the mix-up and backed it up with testimony and those board minutes. Mr. Sopatyk, on the other hand, just couldn't come up with enough hard evidence to knock their story down and tip the scales back in his favor. So with the case closed, what can we all take away from this long and complicated legal fight? What's the big lesson here?
The association's win really came down to a few key things. One, they successfully argued that the $660 fee was for working capital, which their own CC&R is allowed. Two, that meant the actual disclosure fee was that little $30 charge, which was totally fine under the $400 legal cap. And three, most importantly, their testimony and their paper trail supported the, oops, we mislabeled it defense, and the other side just didn't have the ammo to disprove it.
And that really leads us to the big takeaway from this whole thing. The label on the form is what started this entire fight, but it was the substance of the fee, its real purpose and where the money actually went, that decided the case. The association proved the substance was legal, and the judge decided the label was just an honest mistake. This entire case, years of fighting, came down to the specific words in two different documents. So it leaves us with a really important question to think about. When it comes to the rules and fees that govern your own home, how well do you really know what your documents actually say?